It's up to the employer whether or not they furlough any particular employee. There's nothing you can do to force your employer to furlough you. However, you might have a claim against them if their selection process has discriminated against you. For example, if you're the only person with a disability, the only person over a certain age, the only woman, or the only person with any other protected characteristic under the Equality Act, then you could potentially bring a discrimination claim against your employer. You can refuse to be placed on furlough because it represents a change to your employment contract, particularly if your pay is being reduced. You should consider the consequences of refusing to go on furlough, however, because if you refuse to go on furlough, your employer might then move to make you redundant and be able to justify this in the context of the current public health crisis. Employees have a right not to be subject to detriments or dismissals for leaving or refusing to return to work where they reasonably believe there is a serious and imminent danger which they could not reasonably have been expected to avert. If your employer either dismissed you, disciplined you, or otherwise treated you unfavourably following your refusal to attend work due to fears over COVID-19, then this could entitle you to make a claim for unlawful detriment or unfair dismissal, and that applies even if you have not worked with the company for 2 years. It's impossible to know how an employment tribunal will approach these situations because it is an unprecedented situation, but it's important to note that the government itself has described the virus in law as being a serious and imminent threat to public health, and this makes it more likely that employment tribunals will not look favourably on employers who do not take the risks to employee health seriously. Provided that your employment contract does not prohibit it, then you can work for a different employer, provided that other employer is not associated with your current employer. Unfortunately, you cannot do anything about your new employer refusing to take you on. However, you could ask your current or former employer if you can withdraw your resignation. This would allow them to furlough you as if you'd never resigned in the first place. Please remember though that there is no way to force a current or former employer to do this. The choice is entirely theirs. If you're on a 0 hours contract, if you've been employed for 1 year or more, then your employer should claim for 80% of whichever is higher out of the following two scenarios: the amount you earned in the same month last year, or the average of your earnings from the last year. If you've been employed for less than a year, then your payment is based on an average for the months that you have worked in your current job. Yes, provided you're on each company's payroll and paid under the PAYE scheme, each company has the discretion to put you on furlough. Choose.